Hi everyone, how are you doing? Hope you're good. Hope you're fine. Welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. So today we're looking at the use of survey plans in land cases. Uh, you see, in land cases, they are complex because sometimes you see people, disputing, you know, land, the location of the land, someone party A claiming the land belongs to him, party B saying no, that is my land, party A claiming you have encroached on my land, party B saying no, you did not encroach on my land. So land cases are quite complex, and sometimes because the judge who is going to decide these cases, sometimes they don't even know the land unless there's a visit to locus. I know because unless there's visit to locals, they will know the land. So sometimes, in a bid for you to prove your claim in court, in land cases, the expedient that survey plans are what part of the documents you tender in proving your case. So today we're looking at how do you use a survey plan, the types of survey plans we have, you know, and what a survey plan is all about. So you ask yourself, what is a survey plan? It's very important. What is a survey plan? Many people, well, many have seen a survey plan. Many too have seen but cannot even read because they say, I'm not a licensed surveyor, so I may not be able to read the coordinates. But as a lawyer, you should have an idea of everything. You should have a knowledge of how to, even when you see a survey plan, how to be able to note the coordinates, how to note the survey plan number, the basic features. At least you should be able to know all that. Yeah, so a survey plan is what like a true description, representation of what a land on approximate scale, legal boundaries is a plan that shows the legal boundaries of a land, the dimensions, the dimensions of a parcel of land, you know. So sometimes you see that most of the times survey plans are attached to power of attorneys, deed of assignment, a deed of transfer, deed, certificate of occupancy, instruments of titles, instruments of transfer. Now we also have what we call the litigation survey plan, just like I earlier stated in our introduction, that where two people are contesting maybe parcel of land, and one is claiming I own this land, one is claiming you encroached on my land, or one is claiming no, my land is bigger than this, took a part of my land. So litigation survey plans are those survey plans that are done, you know uh having reference to the suit, with the idea of to decipher the actual portion of each party's claim, or each party's land. That's a litigation survey plan. It represents the claims of the parties with reference to features of the land, boundaries of the land in a choosing scale. So litigation survey plan, it is done, because of that suit. You see that on the face of the survey plan, you see the name of the party, the suit number, the court where the suit is what uh, is instituted, the suit is instituted, and the claims of each party. You know, and you remember that litigation survey plans are only prepared with relation to that suit. Just that people just prepare because they maybe for that suit alone, just like I let's say the features of that survey plan, it bears the suit number, party's name, then it will not have different color that verges the particulars of each land in so that it's important to note these things. There are other types of survey plans we also note as in the course of our class today. Now, one of the very important reasons why people do or people draw their survey plan is what to identify their land. What is do I know the dimensions of my land? What is the measurement of my land? Beyond someone telling you it's 500 meters or 10,000 square meters, your survey plan is what now demystifies it to bring it that no, these are the coordinates, this is the measurement, this is the exact, this is where it is, so that a professional can come in a large expanse of land and be able to pick the coordinate and say this is this land on this paper, this is where it is. So where there is dispute in land, the essence of or the purpose of a survey plan is to identify that land what in dispute with what sufficient particularity. What is this particularity? Just like I stated, the dimensions of the land. The dimensions of the land will be stated, the features of, the size, the shape. Sometimes when you see a survey plan, you'll be able to know, okay, this land, is it a square shaped? Is it, what's the dimension in terms of the length? The size of the land, the shape of the land is highly, is particularized, is stated on it, is on the face of the survey plan, you see it. So what a survey plan does is that identifies the land with sufficient, delimiting it with sufficient particularity, for you to now say this is how it is, the morphology, how it's graphically stated. Yes, so that's what the survey plan does for you. Now, that's what we call a counter plan. What is a counter plan? A counter plan is that plan sometimes done by a defendant. Because if it's a case where a claimant is the one claiming the land, a defendant is saying, no, this land you're claiming is also mine. This is part of my land. I didn't encroach on your land. The defendant can do what is called a counter plan, disputing the claims of the plaintiff in the survey plan. You know, it's it challenges the survey plan of the first party. So that's what a counter plan, the defendant will go draw his own plan, describing his own features of his land accurately, which will now counter whatever the other party what is saying. It's very, very important. The case of Achibong and Ita is very important in this regard as per what the court stating what a counter plan is. Achibong and Ita is a 2004 one Supreme Court Nigerian report, one Supreme Court Nigerian judgment. I'm sorry about that. 2004 one Nigerian Supreme Court judgment is very, 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 very key and precise on the issue of what a counter plan is and what it can be used for. And now in a court where issues of land dispute is involved and the survey plans have been drawn, so it's also important for the court to utilize the technical the technical language of that survey plan in describing the plan or in describing the size of the lot for precision and for parties to understand exactly what the court is. It can't use normal lay language in describing all those precisions of a survey plan. Now, there's also something that is called a sketch. Many a times people confuse a sketch for a survey plan. One of the difference between a survey plan and a sketch is that a survey plan is properly oriented and drawn to scale. Is it a scale of 1 to 100? Is it a scale of 20, 1 to 50? Although this requirement of drawing is properly oriented and drawn to scale is not always a feature of a sketch. Sometimes in a sketch, you don't even have a scale by which the drawing is, mentioned. In the case of Ndulue and Ojiako, this distinction between sketch mark and the survey plan was also stated there. In the 2013 8th Nigerian Weekly Law Report, Part 1356, the case of Ndulue and Ojiako, so a sketch most of the time does not have a scale upon which the drawing is um, done, unlike a survey plan wherein it has to have a scale upon which it was drawn by a licensed surveyor. So sometimes you have to understand when a sketch is used and when a survey plan is used. Sometimes sketch maps are used maybe in customary land issues, whereby survey plans are used in a higher court. Though it's not sacrosanct, but you must be able to know what a sketch is. When you see a sketch, this is a sketch. When you see a survey plan, oh, this one is a survey plan. Be able to know the distinguishing factor or the distinguishing traits between a sketch map and a survey plan. It's very, 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 very what important. So we'll look at what we call superimposition of plans. What is superimposition of plans? Where there are two plans. The defendant, the plaintiff, for example, our claimant has done his own plan. Defendant is saying, no, what you drew is not the right location or the right size of the land. Let me do my own counter plan to show the exact location, the size, the description of the land and we are talking about. So what happens in the superimposition of plan is that the court will take these two plans and put it together and now see, is there any difference? Is there any difference? Also note before I forget that where a defendant did not draw a counter plan against the survey plan of the plaintiff, we assume that that defendant has accepted whatsoever that is in that survey plan. So it's important you do a counter plan where there is, you are saying no, I don't believe in what you're saying, it's a lie. Then you have to back it up with a counter plan. So where you did not file your own counter plan, it is deemed to have accepted the boundaries and features of the land in this suit as presented by the plaintiff or or the claimant. So that superimposition of plans is where these two plans are being brought together, placed on top of each other to know, look at the size, look at the coordinates, is it the same? Usually done by the court. So superimposition helps to establish the relationship between the land in dispute against any other land that is claimed in a suit. You know, you put it side by side.
She's here. How are you?
I'm fine, sir. So you put it side by side and be able to see, is there a difference when you place it on top of each other? Say, is there a difference? So superimposition of plan is different from composite plan. Composite plan is done by the Surveyor General of a state, depending on where you're, the federation, depending on where you are, wherein the licensed surveyors in that parastatal organization will take the plans you have and by themselves go and visit the land, which is the visit to the locus, take the coordinates and look at it critically to see, is there an encroachment? Is there an encroachment? Is it the same land? And what is the level of encroachment? They never say it was 2 meters or 3 meters, or this land, overlapped with this one. So many people utilize composite plan. Yes, many people utilize composite plan rather than superimposition of plan because they feel that composite plan is more reliable because it is being done by professionals who knows the coordinates, who will visit the land, who will measure and place it side by side with each other and say, wow, there is an overlap, or this person's land, overlaps or encroaches on this one, and the dimension to which it is done. It is very, very important. So many people utilize survey plan and composite plan. And when composite plan is done, and when you want to tender it in court, you have to subpoena that officer in that parastatal who, you know, drew the composite plan to come and give evidence. So it's by way of you do a subpoena ad testificando or just to stay come to just come and tender that composite plan because your witness can't tender it because it's not the person who drew it. So there will be objection on its admissibility. So when you do a composite plan, they're going to subpoena that officer who helped you to do this composite plan. Is very, very important. Survey plans are very key in deciding issues where lands are in dispute. Survey plan is key. So you cannot just prove these issues of dispute by word of mouth or this person's word against this person's word. Your survey plan is a documentary evidence which is critical in helping resolve these issues of dispute in land cases. I just hope you've learned something today. If you have any question, drop on the comment section. We will answer them. We'll answer them appropriately. If you're yet to subscribe to the channel, please do hit the subscribe button, like the video, and share to your friends. Someone will learn one or two things from this video. Thank you very much.